Saya Iman Prihandono, Dekan pada Fakultas Hukum Universitas Airlangga. Fakultas Hukum Universitas Airlangga ini adalah salah satu fakultas hukum yang tertua di Indonesia. Kami sudah berdiri sejak tahun 1952, bergabung bersama dengan Universitas Airlangga di tahun 1954. Ada setidaknya 4 program studi yang saat ini dijalankan di Fakultas Hukum Universitas Airlangga. Yang pertama, program studi S1 Ilmu Hukum. Yang kedua, program studi Magister Ilmu Hukum. Yang ketiga, program Magister Kenotariatan. Dan yang keempat adalah program studi Doktor Ilmu Hukum untuk S3-nya. Saat ini, Fakultas Hukum Universitas Airlangga memiliki beberapa akreditasi, baik nasional maupun internasional. Di akreditasi nasional, kita punya akreditasi unggul untuk program studi S1 dari BAN PT, sedangkan di akreditasi internasionalnya, kami terakreditasi oleh AUN, ASEAN University Network, lalu juga ada akreditasi FIBA-A, dan kami juga tergabung dalam Asosiasi Fakultas Hukum Dunia. Untuk ranking, Fakultas Hukum Universitas Airlangga di tahun 2021 menempati ranking 250-300 oleh QS World University Ranking. Tidak hanya itu, dalam ranking Times Higher Education, kami juga menempati ranking 201 dunia.
UNAIR merupakan salah satu fakultas hukum terbaik yang terdapat di Indonesia, dan bisa dilihat dari alumni-alumni di luar sana, memang banyak yang menjadi praktisi hukum maupun ahli hukum yang berkompeten di bidangnya.
Setelah masuk Fakultas Hukum, saya mendapatkan segala hal yang sudah saya ekspektasikan sebelumnya, yaitu pembelajaran menggunakan bahasa Inggris, pembelajaran yang juga mengutamakan soft skill dalam artian debate dan discussion. Lalu yang ketiga, sistem pembelajaran dua arah yang sangat aktif antara dosen dan mahasiswa.
Di Fakultas Hukum Universitas Airlangga memiliki koleksi buku yang lengkap, kemudian ruang baca yang nyaman bagi mahasiswa untuk bisa mendapatkan berbagai literatur dan referensi untuk menulis tugas ataupun karya ilmiahnya.
Saya banyak mendapatkan ilmu-ilmu bukan hanya ilmu-ilmu teoritis, tapi juga ilmu-ilmu praktik.
Saya sangat tidak menyesal karena banyak sekali ilmu yang saya dapatkan dan juga dosen-dosennya sangat kredibilitasnya tinggi. Oleh karena itu di sini saya mendapatkan pengalaman yang terbaik.
Nah, itu sekilas gambaran tentang Fakultas Hukum Universitas Airlangga. Sampai jumpa di FH UNAIR.
UNAIR hebat.
UNAIR hebat.
UNAIR hebat, FH best.
FH best.
Halo Ksatria Airlangga, selamat datang di Fakultas Hukum Universitas Airlangga. FH UNAIR terletak di Kampus B, Jalan Dharma Wangsa Dalam Selatan, Airlangga, Surabaya. FH UNAIR merupakan salah satu fakultas tertua di Universitas Airlangga. Saat ini, FH UNAIR mengelola 4 program studi, yaitu Program Studi Ilmu Hukum S1, Program Studi Magister Ilmu Hukum S2, Program Studi Magister Kenotariatan, dan Program Studi Doktor Ilmu Hukum. Tentunya, untuk mempermudah dan menunjang proses pembelajaran, Fakultas Hukum UNAIR menyediakan fasilitas yang tersedia antara lain, sarana utama untuk kegiatan perkuliahan adalah ruang kelas. Setiap program studi sudah diberi data ruang kelas sesuai dengan jumlah mahasiswa, serta fasilitas perangkat komputer, LCD proyektor, audio, dan koneksi Wi-Fi guna mempermudah mahasiswa dalam pembelajaran. Selanjutnya ialah koleksi khusus. Koleksi khusus adalah salah satu unit bagian akademik Fakultas Hukum Universitas Airlangga yang memiliki tugas mengelola karya tulis, karya cetak, atau karya rekam secara profesional dengan sistem yang baku guna memenuhi kebutuhan informasi sivitas akademika. Koleksi khusus yang sering disebut juga dengan istilah ruang baca fakultas memiliki peran penting untuk mendukung terlaksananya tridharma perguruan tinggi, yaitu pendidikan, penelitian, dan pengabdian masyarakat. Selanjutnya ialah ada ruang adiaksa dan aula Pancasila. Ruang adiaksa merupakan ruangan lain yang disediakan oleh Fakultas Hukum untuk program doktor. Ruangan ini biasa digunakan oleh mahasiswa S3 untuk bersantai, membaca, serta berdiskusi antar mahasiswa maupun mahasiswa dengan dosen. Selanjutnya ialah ruangan aula Pancasila. Ruangan ini merupakan aula serbaguna yang biasa difungsikan untuk berbagai macam aktivitas kampus, seperti seminar, loka karya, kuliah umum, dan pengujian program doktor S3. Ruang sarana prasarana. Sebagaimana ruang kuliah, ruang sarana dan prasarana digunakan juga oleh seluruh mahasiswa, khususnya untuk mahasiswa S3 sebagai tempat pelayanan peminjaman buku yang memadai. Selanjutnya merupakan ruang pengelola. Ruang pengelola merupakan ruangan di Fakultas Hukum yang berisi unit-unit khusus untuk menangani permasalahan akademik maupun non-akademik mahasiswa. Seluruh mahasiswa S1, S2, dan S3 Fakultas Hukum telah terintegrasi dengan website resmi mahasiswa UNAIR, yakni Cyber Campus, di mana mahasiswa diharuskan login terlebih dahulu dan memastikan biodata yang diisi telah benar, agar dapat menyusun rancangan program studi yang akan diambil. Di masa pandemi ini, mahasiswa FH UNAIR melakukan ujian secara online, yang mana jadwalnya sudah ditetapkan oleh akademik melalui akun Cyber Campus dan terintegrasi oleh Google Calendar. Itulah fasilitas yang ada di FH UNAIR. Menurut kalian, fasilitas apa yang paling seru? Jangan lupa tulis di kolom komentar. Kami tunggu ya kalian di Fakultas Hukum Universitas Airlangga. Sampai jumpa!
notaris masa depan yang lagi cari kuliah S2, ini aku lagi ada di FH UNAIR, salah satu fakultas hukum tertua di Indonesia yang diresmikan bersamaan dengan 3 fakultas awal pada saat Universitas Airlangga ini didirikan pada tahun 1954. Jadi kualitasnya udah nggak perlu diraguin lagi. Oke, sedikit dulu tentang Magister Kenotariatan. Jadi jurusan ini udah berdiri sejak tahun 1980. Pastinya lebih tua lah ya daripada aku. Dan pastinya udah banyak banget notaris keren jebolan dari MKN ini. Jadi nggak usah banyak ngomong lagi, langsung aja kita keliling-keliling. Jadi untuk mastiin aja, kurikulum di sini udah sesuai dengan standar BKS Kenotariatan perguruan tinggi se-Indonesia. Tapi MKN UNAIR ini juga punya kekhasan dengan adanya fokus di sisi teknik pembuatan akta syariah. Keren kan? Halo Mas.
Halo.
Kuliah sini ya?
Iya.
Jurusan apa Mas?
Aku Magister Kenotariatan.
Oh ya kebetulan, ini aku lagi cari S2 Kenotariatan. Mungkin Masnya bisa cerita gimana sih kuliah di sini?
Kuliah di sini itu ya, kalau menurut aku kombinasinya balance banget. Antara pengetahuan teoritik sama pengetahuan prakteknya.
Oh ya, kalau untuk mata kuliah yang Mas suka apa?
Mata kuliah yang aku suka, favoritnya ada 2 nih. Jadi yang pertama itu adalah teknik pembuatan akta.
Ya.
Terus yang kedua itu analisis perancangan kontrak.
Oh, oke.
Jadi gini, 2 mata kuliah ini ngajarin kita banget caranya bikin dokumen-dokumen hukum. Nah, ini bakal kepake banget buat aku nanti kok udah jadi notaris.
Oh iya. Selain itu, enaknya apa sih Mas kuliah di sini?
Oh, ada. Jadi gini, normalnya kalau kuliah di sini, kita kan 4 semester tuh. Tapi kalau rajin, kita bisa kelarin dalam 3 semester.
Oh bisa gitu ya?
Bisa
3
gitu.
semester? Iya. Ya, cepet juga ya.
Dan kalau yang istimewa lagi ya, jadi kurikulum di sini tuh fleksibel banget. Jadi dia sangat ngikutin sama kebutuhan zaman.
Oh iya. Oke deh Mas, oh gitu makasih ya infonya. Kalau gitu aku mau lanjut keliling lagi. Makasih.
Sama-sama.
Mari.
Assalamualaikum warahmatullahi wabarakatuh. Selamat siang, salam sehat selalu. Kuliah di MKN UNAIR tentunya menjadi pilihan yang tepat. Selain dibimbing oleh dosen-dosen dari akademisi, juga praktisi dari notaris PPAT yang profesional, yang tentunya akan mencetak calon-calon notaris yang handal, calon-calon notaris yang berilmu dan bermartabat. Sukses MKN UNAIR.
Calon-calon notaris, silakan bergabung dengan MKN Universitas Airlangga. Seperti keluarga saya, suami, kedua anak saya, semuanya adalah lulusan dari MKN Universitas Airlangga. Sudah terbukti dan sekarang sudah berprofesi.
Nggak perlu khawatir nggak dapat kerjaan, karena hampir setiap perjanjian atau transaksi bisnis pasti butuh notaris. Lapangan pekerjaannya tuh luas banget. Selain jadi notaris independen, kita juga bisa kerja di bank, BUMN, ASN, dan lain-lain. Aku baca-baca dulu ya, sambil kita lanjut jalan. Oke, jadi ini salah satu ruangan untuk ujian tesis. Oke, ini aku jelasin secara singkat, padat dan jelas ya. Jadi, MKN punya sekitar 41 dosen, diantaranya ada 8 profesor, 21 doktor, 10 notaris, dan 2 praktisi hukum. Kuliahnya juga fleksibel banget loh, bisa online dan ada kelas malam juga. Dan untuk bantuin kita belajar, kita bisa akses beberapa jurnal yang emang udah langganan seperti website koleksi khusus atau lib.unair.ac.id. Antara lain Westlaw Publishing, Kluwer Law, Gestor, Cambridge, dan lain-lain.
Ini sudah bisa dipakai. Di podcast kita pada siang hari ini, salam dari Fakultas Hukum Universitas Airlangga. Hari ini ada tamu spesial di Fakultas Hukum, adalah Profesor Tinneke Lambooy dan Dr. Bart Jansen dari University Netherlands. Kita akan berdiskusi santai sebenarnya di siang hari ini untuk bicara mengenai publikasi. Untuk itu, untuk mulai acara ini, saya mohon maaf untuk beralih ke bahasa Inggris. Bapak Ibu sekalian yang ada di rumah atau dimanapun Anda berada, jika nanti ada pertanyaan, ini akan sedikit interaktif, langsung saja raise hand. Nanti kita akan langsung berdiskusi, jadi tidak perlu menunggu selesai presentasi, karena ini kita obrolan santai. Targetnya adalah kita bagaimana kemudian bisa memaksimalkan potensi publikasi kita. Profesor Tinneke sudah tidak asing lagi di fakultas. Beliau lebih dari satu dekade ini bersama kita, bersama dengan Bart Jansen, membantu kita di Fakultas Hukum, dan beliau juga aktif di Juridika. So, goedemiddag Profesor Tinneke. Goedemiddag. Welcome naar Surabaya. Ja, suka funny. I use Dutch, you use Indonesia. Okay. As already we discussed, Professor Tinneke and Dr. Bart Jansen, our faculty now in the QS World Ranking is in 101 and 150, and why we already in that position, because of course by the most important thing is publication. So the publication is important for our faculty and also university. I give you a number, for example, this year's the university give us a target minimum 60 journals published by our lecturer in Scopus Index Journal.
Every year?
Yeah, this year. This is the target for this year. 60
articles.
Yeah,
60 papers.
Yeah, 60 papers. It's
Recording in progress.
And then, yeah, 60. And then for citation, we get a target 432 citation in Scopus. So not only published, but we also struggle to how to make our paper cited by another author. And then we also have target for lecturer 16 proceeding in international conference index by Scopus 2. And then for students is higher than our lecturer. The student have get the target 105 papers.
Like master students, or you mean
Yeah,
PhD
it's for
students?
all students, both for bachelor to the PhD student. So it's quite challenging.
So,
Yeah, every year we must struggle to how to make our target accomplished. That's why by this podcast today, we hope get share experience for you, Professor Tinneke and Bart, how to make a good articles, and then how to make our article visible to another author, and how to make our paper cited by another author. Right now, also in our faculty now we have 4 journals. Juridika, as you are become the important part in the Juridika, it's already national accredited, Sinta 2. And then this year we have planned to resubmit to the Scopus. We hope that Juridika will be accredited by Scopus this year. We have planned in the end of this year we submit to the Scopus. And also we have Media Juris, is journal in our Master of Laws. It's already accredited by Sintatu. And then also for notariat, we have a notary journal. And also in bachelor degree, we have jurisdiction journal. So, and also all of our research funding, especially internal research funding, have the researcher have obligation to publish their research as a research output to the journal, especially the Scopus journal. So it is important for our researcher, if they want to access our funding, they must make sure that the research will be published in Scopus journal.
What is the difference between Juridica and Meta Juris?
For Juridica, this is the journal in Faculty of Law, and then for the Media Juris is a journal in Master of Laws.
Master of Laws,
yeah, Master of Law, yeah.
Clear.
And then for publication, it's also obligation for all of our students. PhD students, before they go to the PhD defense, they must be published in journal. Yeah, in a minimum one journal before they can go to the PhD defense. And then for Master of Law, it's have the similar policy, but in Master of Law, it's only national accredited journal. But in PhD, they asked to go to the international accredited journal. So it's quite challenging. So it's also become the challenge not only for the student, but also for the lecturer. So I think Professor Tinneke, you have, maybe you can share your experience how to publish in the international journal.
Yeah, we've prepared a presentation on the writing and publishing in international law reviews and journals, and also books and other types of publications. Yes. Well, thank you very much, Maradona, for introducing us and also inviting us to this podcast. We will try to make it a bit of an interactive clinic, because you have announced it as a clinic on legal writing. So we will ask the participants to also share their thoughts in the chat. So please make use of the chat function, and we will try to respond to that. Hi guys, yes, everyone. And of course, we are here for another week, so you can also contact us if you have further questions, or if you want to maybe do some joint research. We already have some joint publications with the Pade Khan, Iman Priyandano, and Nurul Parizar, and with Dr. Faisal
and Anida.
And we have Juridica together with the editorial board with Prawitra and other people. So we have the special issue in the Juridica. And we're preparing further joint papers, which is good for you and good for us, because also UNAIR, the business university, where we are from in the Netherlands, we also have publication targets, maybe not so high as your targets, but for us, we have to publish in international journals with business accreditation points, and that's also quite difficult. So we have to think about how to structure a good research question and write a good paper that is interesting for, of course, yourself. Otherwise, you cannot work on it for many hours, and also interesting for the people who are going to read it, because you have to add something to the, World Library or Indonesian Library. So let's start with introducing. So I'm Professor Corporate Law at UNAIR, the Business University, and adjunct professor here at Universitas Erlangga. And this is my colleague, Dr. Bart Jansen, assistant professor at UNAIR, the Business University, legal ethics and business ethics, and also in general law. I think you also teach law, and adjunct professor here at Erlangga University. So let's go to the first sheet. If you are writing a paper, it is important to really contribute something to the general body of knowledge. I mean, it must be something new or a new perspective, because there's no point in rewriting the same story. If other people have published on a certain topic, maybe when you have a very different opinion that you can motivate and substantiate with good arguments, but you have to write something new. And it's important because it promotes the quality of lawmaking. So it will be used by judges and by lawyers and by also members of parliament. That's what we see in the Netherlands a lot, that members of parliament are pointing to our articles, and that leads sometimes to new legislation. We see that in the social enterprise legislation. My colleague Aikaterina Aigiru, Dr. Aikaterina Aigiru, and me, we publish a lot about social enterprises, and that social enterprises need a special legal form, so different from the Dutch limited liability company form and limited from the foundation legal form, the JSAN and the PT. So you need something that combines elements of both. And so we wrote many articles about it and did presentations, and now the lawmakers have agreed to introduce a new legal form. So you also, it helps when you want to make an impact, a societal impact. But of course, also judges and other lawyers, they will also read your papers when they are working on a case. So let's go to the next slide. So what are the considerations for writing a good academic legal article? So first is, where do you want to publish your article? Do you want to publish it in an international journal? And then the question is it a legal journal or a social science journal, or maybe economic journal, business journal, or ethics journal? So every type of journal has different standards. Or do you want to publish it in a domestic journal? And then if so, is it a legal journal or is it another discipline? Of course, you can also write a book chapter, for instance, with one of the international publishers, that you edit a book or you contribute to an edited volume of a book. And then the best ones are the Cambridge, or the most cited ones are the Cambridge University Press and Oxford University Press and Routledge and Springer and Edgar Elgar. Yeah, so there are some mainstream international publishers, Kluwer International for law, important. So that's also a way of publishing an article to make a book chapter. Or what you can do is to write a review about a new book. So if there's a new book published on onrechtmatige daad, on tort, for instance, you can write a review of that book. And a review does not only mean I like it or I don't like it. It's also that you compare it with the existing body of books on onrechtmatige daad, and that you indicate what is new in this new book. Yeah, so you can do it that way. You can also organize a special issue like what we did with Juridika, and then you make it sort of an edited volume, but then of a journal issue. So that means that you have quite some influence on the topic and also on the authors that you invite to write. So you can have a coherent general theme of the topic, and also invite people from authors from other countries so that you have an international special issue. Yes, so that's the first question. For whom are you going to write the paper? And then who is going to write the paper? Who is going to read the paper, I mean? What is the audience? Is the audience academic audience, like people in universities who are using it when they're writing their papers and teaching? Or is it for teaching materials? So is it students? Then you have to explain things in more simple ways. Or is it practitioners, like people who work in a law firm or with a company or with the government? Because people who are practitioner, you need to help them a little bit more in making things more concrete. So you need to use more examples, make it more tangible. In general, I like it best when you make things more concrete, when you explain how it impacts society. But that's not the only way to write articles. And I think, Bart, maybe you want to contribute to this. And that type of articles that you write for business ethics are not so concrete. Some are, like the one about your hospitality management, but some are not. Maybe you want to say something about the non-practical, the more theoretical ones.
Yeah, it's good to think who your audience is indeed, and is your audience more are they practitioners? Then you have to use more examples. Is the audience more academic? Then you can use less examples. And there is also within the academy a difference between disciplines. So if you write an article for the legal discipline, you have to be concrete. You have to apply the laws in a concrete situation. I am a lawyer, but I'm also a philosopher, and philosophical papers are more like essays, so they are less concrete. You use less examples, and they are more abstract and more theoretical. So you have differences in audience, and that audience divides in different disciplines.
So, for example, in the dissertation of Bart, he wrote one article about the question when a doctor takes your leg off because your leg is ill, infected or whatever is the reason. Who is the owner of the leg? And you can say it's a theoretical question or a philosophical question or a practical question or a matter of hygiene. So in his book, he had the different perspectives in different articles and then combined in one chapter. So he analyzed it from a private law perspective, from
a health law perspective, human rights perspective, but also from a philosophical and an ethical perspective. But these different perspectives were divided in different articles in different journals, because every journal has its own audience, and it is very important to recognize that.
That is exactly my question. How we know that certain journal with a certain audience? Because if we have a paper, for example, and we want to choose a journal, how do we know that who is the reader of this journal?
I think it's very important to read some articles of a journal where you want to write for before you submit an article to that journal. Because if you read some articles in a journal, you know what the character is of the journal, you know what the soul is of the journal.
But also you can read it on the website. So usually on the website it will say that it's for academic purposes or it's for practitioners or for both, which can also be the case. And in the Netherlands, I know exactly which legal journals are more of an academic nature and which journals are more of a practical nature. So actually, for your own domestic jurisdiction, you probably know this, and you can find it out on the website. And then, indeed, what Bart is saying, that you have to read some papers published in that journal to see what style of writing the journal likes best, and also to find out what in this journal has been written about your topic, so that you can refer to it. So that you're not repeating the same articles that have been published in that journal. So you need to refer back to previously published papers on the same topic. And you have to say, I'm building further on that body of knowledge.
Be gentle to the editorial, to the editors.
So, okay, and then you have to find out what is the required maximum length of the article. So what we see in general is that articles must be shorter and shorter and shorter nowadays. So where maybe 20 years ago you could publish an article of 15,000 words or 20,000 words. Today, most journals like best if you publish an article of 6,000 to 8,000 words. And also book chapters have become shorter. So that means when you write an article, you can write it in a long version for yourself, but then you need to condense it. You need to make it shorter. You may need to make the sentences shorter. You need to decide, okay, this was interesting for myself, but it's not so interesting for the audience. So I can take this part out. So you need to make a really short story, but with a lot of information in it. So it's not only that it's only shorter, less information. So you need to find out at the website of the newspaper, of the article, the website of the journal or of the book editors. You need to find out what is the required length. And then you need to find out when you can submit it and where. And very often journals also have special issues. So then you can submit an abstract. And if you are selected, then you're invited to write a paper. And then they will do peer review. So they will still not promise you that it will be published, but then at least you get a chance to submit something. Like I'm the editor of the International Comparative and Corporate Law Journal. And also I'm one of the chief editors. Within the editorial board, we also have Ibu UNAIR and Prawitra. Yeah, so then they are peer reviewers. So if there's an article coming that concerns Indonesian law, we will send it to them for the peer review. So then you get it back. There are always two peer reviewers. You get it back with comments and questions, and you have to revise it a bit, and then you submit it again, and maybe you get it back one more time, and then you submit it again, and then you get the proofs and you read them. Well, a legal researcher must be systematic, methodical, efficient, and analytical. Well, that's not new. So let's go to the abstract. Every paper starts with an abstract. You have to write for yourself the goal of the paper, of the article. And maybe in the end, you will change your abstract from the beginning because things were a bit different. So you start with an initial abstract and you ask yourself, I want to write about this topic. And why is it relevant? Is it relevant for the society, like my example of the social enterprise legal form? Or is it a strictly legal or theoretical discussion that I want to contribute to, which is also important because we also need fundamental discussions. So, and here we have
Prawitra. Selamat datang, Pak Prawitra.
So, why is the issue at hand relevant? And then the theory, you need to base your story, your argument on theory. So what has been published before on this subject and what are the gaps? Because you cannot repeat somebody else's paper or opinion or study. So you have to explain to the reader, this is the theory, and some things have never been addressed. And that is why I write this paper. So you have to do a gap analysis. So you can read other papers on that topic in the same journal, but also in other journals and in handbooks and in jurisprudence. So then the third point in your abstract is what is exactly the research question you wish to answer? Because if I'm concerned about climate change and I'm thinking about writing about climate change tax, that there maybe was a legislative proposal in Indonesia, but it was withdrawn. That is only descriptive. That is not really research. That is only updating the reader that something happened. So you need to have a research question. You could do that by comparing it to CO2 tax laws in other countries. Maybe there are one in Australia or in Europe or in the US. So then you get comparative legal analysis. So that could be the research question. And then usually when there's a broad research question, you will also need some sub-research questions. And then when you have formulated your research question, you need to explain in which way you want to answer it. So what is your methodology? And you have to describe that really clearly. And as lawyers, we're not used to do that. But in social science, you have to do that. Otherwise, you get not your paper published. So methodology could be comparative legal research, or it could be a case study, or it could be discussion of a new case, like jurisprudence discussion and compare with other cases. So I will come back to that in a minute. Then you have to present the results. So you did your, you applied the methodology, and then there are results. So you found, for instance, other cases on the same topic, or you found some other laws on the same topic of carbon credits or carbon tax. And then without discussion, you can present them. And then after that, you need to relate them to the theory. So what is the theory, the body of knowledge that is already there, and what are you adding with your results to that theory? So then you discuss the results in light of the theory, and do the results really provide an answer to the research question? So and then the end is the concluding remarks, and maybe there are still some new questions, so you can indicate that there is room for further research. You cannot answer all the questions in the world in one paper. So at the end of every paper, you will find other questions, like these are questions for further research. And you also have to explain what are the limitations of the study. Like, I only looked at the court cases of the Supreme Court. I didn't look at the court cases of the Courts of Appeal and the district courts. Or maybe the limitation is I only looked at the Dutch situation and the Indonesian situation and the Australian situation in my comparison on carbon tax. And that's a limitation because I didn't look at many other countries. But maybe I also have an explanation for that, because the Dutch and the Indonesian system have a joint history. So that's why I wanted to compare the two systems. So you have to explain that. So now I want to ask the audience, please take 2 minutes and formulate a research question of a topic, on a topic which you wish to explore in the near future. So maybe in 2022, 2022,
ya.
Yeah, you want to write an article. So think 2 minutes about a research question and put that in the chat or raise your hand and then we can listen to you.
Oke. Baik, Bapak Ibu sekalian, Anda punya waktu 2 menit. Silahkan ketik di kolom chat riset question saja tentang rencana penelitian Anda. Mungkin teman-teman dari program studi doktoral, silahkan Anda chat di kolom chat, ketik di kolom chat research question. Nanti kita akan diskusikan research question yang Anda rencanakan ya. Penelitian yang akan rencanakan di tahun ini akan bicara tentang apa. Kita tunggu 2 menit.
So also you too? You also need to publish.
I'll give the floor to Mr. Prawitra. Since Mr. Prawitra already here.
Yeah, thank you. First of all,
we wait for 2 minutes, Pak Witra, untuk mereka ngetik.
I'm so sorry because I'm being so late to Tinneke and Bart. Yeah, and I welcome you in a late decision too, because yes, just like Mr. Maradona said, sometimes we have more than one duties on our shoulders. Our shoulders, I have 2 shoulders, but our duties more than 2. But about the what I will write in the 2022, perhaps it is right now it became a second goal for me, because our first goal in 2022 is to make sure the Juridika is indexed by Scopus. And it is honorable for me to accept that Professor Tinneke, because you are in the Juridika, you can see your name as the editor-in-chief.
Yeah.
So,
Saya tahu.
yeah. So in the next week, around the 18 and 19 May, the Center of Publication in the university want to eagerly to visit you. So we will make some kind of FGD, focus discussion group or workshop. So the LibJPHKI, the center of publication in the university, that the center to have a charge around all of the journal in the university, because they want to eagerly to meet, where's your editor-in-chief? Where is your editor-in-chief? I said, right now, she already have opportunity to come in Surabaya. Yep. So I will make sure we will meet her, and we will talking about the preparation Juridica in the Scopus. So the center of the publication will evaluate us and give some assessment to us, so they can show some flaw in our OJS perhaps in the front of the editor-in-chief. That's a very valuable moment for us. Yeah.
Very good. So, Bart, do we have some proposals in the chat?
No.
Please. Please.
Don't be shy.
Yeah. Only 10 words, like 10 words a research
Mungkin
question.
perlu dijelaskan Pak Wadek.
And you can also put it
in
later.
bahasa, ya put in
dalam bahasa Indonesia pun tidak apa-apa.
Okay.
Tinneke dapat berbahasa Indonesia.
And you can also put it later, because we will come back to it in the end, so you can think about it. So, for example, I have a purpose. I want to write an article jointly with people from Erlangga University, Fakultas Hukum, on rights of nature. So you have probably read that in New Zealand and in Australia, rights have been given to nature entities like a mountain or a river or a piece of land. So it has an independent right. It even has legal personality, like a company, like a municipality, like a church. So those are objects that are not real people like us here at the table, but they still have legal personality. The state of Indonesia has legal personality. So what has been done in Bangladesh, in India, in New Zealand, in Australia, in the United States, in Spain, in Ireland, everywhere in the world, there are examples now, except for China and Russia, where pieces of nature have been given rights, sometimes legal personality, sometimes the right that other people on behalf of the river can complain in court when there is pollution. So when there's a damage to the nature. Very active in this area are Ecuador and Colombia and Bolivia. So what I want to do is to research what are the options in Indonesia, or what new developments are there in Indonesia to also think about this. Okay. So in the Netherlands, we have a small sea in the north, which is UNESCO cultural heritage, natural heritage. It's the Wadden Sea with islands. So we are trying to propose to the parliament to give rights to the Wadden Sea, to make it a legal person. And why? The main reason is to create protection of the environment. So when the government decides that there can be gas exploration in the soil under the Wadden Sea, then the Wadden Sea as a legal person can sit at the table and can say, well, Dutch government, and when I look at all the international treaties that you signed, you promised that the Wadden Sea would be a protected natural area, protected for the birds, the migratory birds, protected for the fish and the seals that live there. So actually, I'm the Wadden Sea, the idea of gas exploration is not a good idea. So maybe you should do it somewhere else, not in this protected area. Okay. So it includes nature as a stakeholder at the table, in addition to NGOs that already represent nature. But the NGOs don't have time to represent every part of nature in the Netherlands. Yeah. So it would be, that is my research idea.
Is the sea near the Groningen? Because there is a gas exploration near the Groningen.
Yeah.
Okay. So how important the comparative perspective in our paper? Can we just talk about our country, for example, and we show that this is our problem in our country, and this is the problem solving in our country. Yeah. So,
well, it's an international development. So I'm curious, it could be a descriptive paper. I'm curious to compare what the initiatives are in Indonesia and also what the technique could be. What could you make it a legal person or not? And where would it fit in the Company Act or in one of the other acts? So it's also a legal analysis.
Okay.
So that's a research idea.
Yeah, we already have one audience. Maybe you can turn on your camera and your microphone. You can talk directly to us. Mr. Bintang Aulia Utama. Good afternoon, Mr. Bintang. Ada, Mr. Bintang.
That's not Bintang. That's Benny.
Benny.
The wrong person. You take.
So, but Bart, can you respond to this? Is this a good research question or is it too broad? So my research question was too broad. Still need to tailor make it.
Let's have a look. I would like to write about the philosophy aspect of bankruptcy law between Indonesia and the Netherlands. Thanks. Well, the topic is, of course, very good and very interesting, but it has to be narrowed down. So, what is the philosophical aspect of bankruptcy law? And what do you want to do with the comparison between Indonesia and the Netherlands? Because there are a lot of ways to do comparative law. So you have a normal approach that is an institutional legal comparison, but you have also an legal anthropological comparison, or a normal or more semantic comparison, a semiotic comparison, a cultural legal comparison. So you have to choose which comparison you want to do.
So he proposes the philosophy aspect. So what is behind the bankruptcy law in Indonesia and in the Netherlands? Would that be a good topic?
Yeah, it is a good topic. Choose which philosophy, because there are a lot of different philosophies, of course. So you have to
say the motivation.
The motivation, but is it philosophical? It's more sociological, I think.
Oh, yes.
A philosophy is, you can choose between a legal positivist approach and a naturalist approach, of course. And if you choose for a legal positivist approach, you have to choose for a descriptive or a normative legal positivist approach. So I think you have to choose which approach the philosophical part is. And maybe also which part of bankruptcy law is important for your paper, because
so
I think
companies or individual people.
Yeah. Because if you take all the bankruptcy law, then I think you should write a dissertation and not a paper of 6,000 words.
Yeah, maybe a handbook.
Or a handbook, maybe better.
But it is a good topic, I think, and maybe also interesting topic for a joint paper between Dutch scholars like Ingrid, our colleague, Ingrid Koning, who's bankruptcy specialist.
Yeah, definitely.
Yeah, together with Pa Bintang. Yeah, okay. Thank you so very much for submitting your research questions. So let's go to the next slide. And please, audience, participants, continue with putting proposals for research questions.
And excuse me, Tinneke, before I came here in this room, so you have fans want to eagerly meet you. That's Mr. Sudirman. He is a PhD student. Want to see you directly, meet you face to face. He came from the Celebes Island, Northeast Celebes Island. When he here, you came in the Surabaya. He already just bought the ticket and flight, almost 3 hours, 3 hour flight from the Celebes Island to the Java Island, only to see you and Bart.
Maybe Mr. Want to discuss about your topics?
It's okay, bahasa saja, no problem. Mr. Maradona and I will translate for Tinneke.
Kita tentang riset topiknya.
Riset topiknya.
You want to come here?
Ya, dari sini silakan. Ada.
Yeah, you can come here.
Here.
Selamat datang.
ceritakan aja riset questnya tentang apa. Kalau sebentar bahasa Inggris,
Yes. Thank you. My name is Sudirman. Is program studi doktoral Universitas Airlangga. Prof Tinneke, my topik disertasi saya Pak, Pak Dr. Maradona, katanya dengan karakteristik lembaga jaminan syariah di Indonesia, khususnya hak tanggungan. Jadi dalam hal ini risetnya kita akan menemukan satu bentuk tatanan hukum kaitannya dengan hak tanggungan yang selama ini secara syariah compliant, kepatuhan syariah, itu saya menganggapnya belum ada harmonisasi antara agreement perjanjian pokok dengan perjanjian aksesorir dalam hal ini. Sehingga arah penelitian saya nantinya akan bukan menemukan suatu tatanan hukum baru dalam bentuk peraturan pemerintah, sehingga lembaga perbankan antara konvensional dan syariah itu akan berbeda dalam bentuk draft akte. My name is profesi notaris.
This topic is about the Islamic mortgage and conventional mortgage.
Yes.
Because our perhaps I will explain to Tinneke what will Mr. Sudirman write in the dissertation is about the comparison between characteristic on Islamic mortgage and conventional mortgage. Because in Indonesia, just like we know, there are we adopted dual banking system, conventional banking and Islamic banking. Meanwhile, the mortgage that two kind of bank using in Indonesia, only one mortgage, conventional mortgage. So that's the issue want to write in the dissertation of Mr. Sudirman. He want to find some kind of characteristic the conventional mortgage that are unrelated to the Islamic mortgage. Because if we want to make sure 100% Islamic banking using 100% Islamic mortgage, conventional banking using conventional mortgage, but on practically it's not like that. Islamic banking, conventional banking using the same mortgage. That's the issue want to read in dissertasi Mr. Sudirman.
Very interesting. Yes. Very interesting. And I know that my husband, who is a banking lawyer in the Netherlands, that he also did some study for Dutch banks on the question how to construct a mortgage for houses in the way that it is Sharia compliant. So I can maybe find out and connect you with him, and maybe you can have a conversation. We can talk about this after the podcast today. Yeah, we can talk about it. I think it's a very good research question because it's also practical. It has practical relevance for banks and for mortgage institutes and for people who are buying a house and don't have all the money themselves, and who want to be compliant. Yeah.
Yes.
Okay. Thank you. So we'll continue.
Yeah. Okay, then we continue with the rules. So can you go to the next slide?
Yeah.
So the rules of academia apply at all times. So the reader should be able to understand step by step the author and the legal writing, and to control and criticize and further elaborate on the research carried out, and to read a clear and uniform presentation of notions, ideas, and arguments. So if you write an academic article, you have to take the reader by the hand. So you have to, step by step, explain what is the goal of your paper, what is the research question, what is the academic relevance, how are you answering the question, what is the methodology, the reader should be able to copy your research. That is why you have to explain in detail the methodology so that somebody else can also do the same research and see if he gets the same research results. And then you have to present it in a clear way. Can we go to the next slide? So to choose a subject, because you're going to dive into it, it must interest the writer, to intrigue the writer, and it must definitely add something to legal academia. And it is best if it has societal impact, so to increase the general body of legal knowledge. And then there are two ways that you can do this. You can choose a subject that has a lot of literature already, like onrechtmatige daad, like tort, and then you can find a new angle to discuss a new question, like the Shell case in the Netherlands, so in which the court said Shell has to reduce 45% of CO2 within the next 8 years. So by 2030, they should have realized the 45% reduction. It is based on tort, Dutch tort law. And Dutch tort law is almost exactly the same as Indonesian tort law. So it is already, there is already a vast amount of literature about tort, but there's a really interesting question here, which is the question of causality and proportionality. So Mr. Padekan is going to research this topic. Well, that is an example of a broad question that you can have studied with a new angle. Another way of finding a subject is to look for a new subject, like my subject, Rights of Nature. There's not written much about it. So I need to gather the raw material and organize it to prepare an analysis. So what I did is I collected 400 examples in all countries in the world of rights of nature. I put them in a database together with a team of researchers, and we compared all those examples, all those initiatives on motivation. So what is the motivation for this right of nature of the people? What is the form? Who is the authority that gave the rights of nature? So that is a new topic. And then actually what we did is empirical data gathering and then apply a taxonomy, actually develop a taxonomy of that. Yeah. Okay, let's go to the next slide.
Before we move to the next slide, we have one question on YouTube. So Lutfi Adiwinata, he asked, do the reviewer of either international or national journal access or check the article purely by academic aspect?
Yes.
So that's the question. Yeah,
definitely.
Definitely.
And the reviewer will always say, you need to find more literature, you have to compare, and usually the reviewer knows a lot about the topic. So he will maybe also, or she, make suggestions for other literature, or sometimes even an argument. Like we had very tough peer reviewers in another article about rights of nature. And one of the peer reviewers, he was quite against it. So he had very, very tough questions, but he said, okay, you are allowed to disagree with me. So when you reply, you have to politely reply. So you say, okay, very good suggestion. Thank you so much. My article is now better. I have implemented it. Or you say, it's a very interesting point that you make, but I'm afraid I disagree. And the reasons
because the reviewers have the strongest position in that.
But if that the answer, when you say the disagree, you will know the consequences.
No, that's not true, because the peer reviewer is a peer reviewer.
The article will not be published in the journal. That's right.
No, that's not true. It can still be published because the decision is being taken by the chief editors, by the editorial board. The peer reviewer are only advices and recommendations to the editorial board. So sometimes they're from the journal's editorial board, sometimes they're outside. Usually you look for people who know a lot about the topic, like about bankruptcy and philosophy. Then you would find two peer reviewers, one on bankruptcy law, one on philosophy, and maybe one on Dutch and one on Indonesian law. Maybe sometimes 4 peer reviewers.
So if the chief editor have a golden heart like Professor Tinneke, he will change the reviewer, perhaps like that.
No, you don't need to change a reviewer, but it's an advice to the editorial board to accept the journal. So it could be a very good academic standard.
Yes.
But the opinion is different from the opinion from the peer reviewer. So that's still valuable to publish.
Okay, that's the possibility. Yeah.
The editorial board will say, well, take this into account.
Yeah.
Right.
Okay. Thank you, Professor Tinneke.
Thanks for the
answer,
enlightenment.
Okay, so choosing a subject. Bart, do you want to?
Yeah, of course. Well, first I want to say that if you are not interested in your topic, then it's going to be a very bad paper in the first place. So choose a subject what you want to choose and where you want to write about for 2 months or so, or more. So how do you find a subject? I think if you are a private lawyer, then your subject is not something in the field of criminal law. It can be, but it must be overlapped with your own discipline. I think that is a good advice. Our second recommendation is that you determine the type of academic legal research that you want to undertake. So you have to narrow it down. The third is that you determine whether you will examine the substantive or procedural aspect of the subject. So we also know that law has something to do with a formal side and a material side, and what is of your interest. What are the most important developments in the field? Follow judgments, follow the change in laws. Search law materials, so judicial decisions, legislative proposals, legal journals and legal books, handbooks. Start always with a handbook. Then go to the developments and use legal databases and catalogs. Most important, we think. Most important thing about the research question is that you have to narrow down your subject. So you can maybe write about about the research question. What are the solutions for climate change problem? That is too broad. You have to narrow it down. And narrow it down is crucial for writing a good paper. Because like Tinneke said, you have to deal with a maximum amount of words. And these days, the maximum amount of words is 8,000 words. Some journals do more words, but most of the journals do 8,000 to 6,000 words. 6,000 to 8,000 words. Many times authors keep their subject too broad, summing details without getting the key question or proposition. So try to collect all the knowledge you have in short sentences. Techniques that can help in narrowing down a subject through systematic exploration are use your imaginations, like a zoom lens. Look through a cylinder and ask several questions on the large topic, for example, by putting it as a definition or a comparison with what caused the subject to develop like it did. What I said, choose a certain field of study. So choose criminal law, choose administrative law. If you choose administrative law, maybe you choose more specifically environmental law. If you do something in one field of law, of course, if you do legal comparison, then you have to choose between different legal fields. That is possible. For instance, if you choose for tax law, which has overlap with administrative law and criminal law, or between countries like the Netherlands or Indonesia. it is very important that you describe why you choose a certain field. So why did you choose for criminal law? What are the objectives of your research related to that legal field? I saw a question, right, or not?
Yes.
No, not anymore.
No, not anymore.
A question about the publication fee, right now.
Publication fee.
Yes. That's.
Yeah, I come to that in a minute.
Okay. Ditanyakan Mas Bek di pertanyaan di atas.
Oh, I can answer it now.
Oh, okay.
Yeah. So what is actually the question of what is the function of a publication fee? The argument is that the government in many countries pays money to universities so that universities can be up and running. So if you work in a university and you do research, the argument is that research, that the output of the research, the article, should be available to all. So open access, because already tax money has been used for the research to pay your salary. So when you have an open access paper, that means that the publisher, so the publisher of the journal or the book, does not have a business model anymore. Because when he publishes everything for free, when you don't have to pay for your books or your PDFs or your journals, the publisher does not earn any money. And the publisher's business model is to earn money by selling journals or selling books, even online in e-copies. And what is the work that a publisher does? A publisher, first of all, makes a selection for the publication. Second of all, formats it so that it's in a good format. Does proofreading, usually for English or for language mistakes. And then marketing of the journal and of the book, otherwise you don't know it exists. So they have to maintain a website, they have to send newsletters, there's a new book that has been published. They send the books to the libraries of universities and of law firms. They have subscriptions of law firms and libraries. So the moment that you say all research output should be open access, there's a problem because nobody is going to publish it except for Juridica. But that's a university journal. Yeah, and that is why it's not in Scopus, and you have to fight for it to be part of Scopus. Yeah. So that is why publishers ask for a publication fee. And of course, it's difficult because if you're a student or a PhD student, you don't have any money for these type of fees. So you have to ask your university to sponsor you. But then the university has a certain budget and that already has been, allocated. So that's also difficult. So when this is the new trend to open access journals, the university have to budget for open access fees and to also negotiate with the publishers what is the maximum that they can pay per article. So yeah, this is a new development that also in the Netherlands, we are really struggling with, like what is the good reason for it and who is going to pay for it. And of course, it's nice if everything is open access, but finally, who's going to read it? You also need marketing. Otherwise, people don't know that it's there.
Even the University of Harvard was complaining about the costs of databases.
How about the predatory journal? Because now there are so many offers from predatory journal.
Yeah.
You want to pay some money, and then I will publish.
Perhaps the most dangerous threat is not came from the predatory journal, I think, but the discontinuous Scopus journal, because when we submit the article, the journal is indexed by Scopus, but when the article is published, the journal is not discontinued by the Scopus.
Yeah, so it could be the case that sometimes a journal merges with another journal, or it gets a new name, or it disappears, and then you lose your Scopus indication. You lose your points?
Yes,
That's strange because normally you should keep what you have earned in the past.
Oh, because the point, when we get the point from the journal, when we using the point will not will not lose.
Yeah.
But when we not using the point yet, and when we want to using the point, the journal is discontinued from the corpus, we cannot use that point anymore. That's our rules.
Okay, but then you have to reconsider the rules because what you have earned in the past should stay forever with you, I think, because you earned it at that time in a honest way and in a fair way.
Yes, that's the reason we create this podcast, because it is borderless, limitless. So if perhaps in our pray, the policymaker will see this, so they will change the policy.
And about predatory journals, that's really wow, thank you. Party time. Predatory journals are really a problem. So you get a lot of emails and they ask, do you want to publish for this journal? And then it's a very nice titled journal like environmental law or a law in society.
A few days ago, I received an email from Journal of Philosophy, and I thought, well, maybe this is a normal one, but it wasn't.
So you have to Google it and to see whether it's in the Scopus or in the SSRN or in the ResearchGate. So you have to find out whether it's maybe non-existing or predatory in the terms of just copying other people's research work. And you have to be really careful for that because it's always presented in an attractive way. But you need to go to the real articles that have a real publisher and real academic points. Okay, should I continue?
Yes.
Otherwise we won't.
Thank you, Pratnya Wijaksana, for your question.
Yes.
You see it? Developing a problem definition. Yes.
Okay. Shall I continue?
Yes.
So this already we discussed. So if you have chosen the area, then you have to do a pre-study. So you have to study what has been published on your research question to make sure that your approach is innovative. And then you have to indicate where the gaps are. So make it explicit. So what you want to study is a gap. There has not been a publication about it. Then you have to define the problem definition or the research question in the introduction of the article, and to define the research area as narrow as possible. And the research question always should be answered in the conclusion of the paper. And then we go to the next slide. So very important is, I think we go to the next slide, developing a problem definition. So you can do a comparative problem definition. So comparative between different fields of law, or comparative between different decisions of courts, different cases, or comparative between different law systems like Indonesia and Thailand, or Indonesia and Australia, or Indonesia and the Netherlands. And then you pick out one question and you're going to compare the text in the laws in the Netherlands and in Indonesia, or you're going to compare the case studies on a certain question, or the motivation for a certain law, like we just discussed the bankruptcy law. And then you can also do it in a different way, that the problem definition is more asking for cause and effect, so an explanatory problem definition. So then you would look for the sources and underlying reasons or explanations that will be, that can explain the situation today. So we did that for the social enterprise studies. We explained the history and the forms that social enterprises were using for their business enterprise, and what the problems were and what they needed for the future. So that's the third one, the predicting the problem definition. So we suggested that we needed a new form in our Company Act, a new form, a legal form for social enterprises. Okay, then we go to the next slide. So if you have the research question, you usually also have some sub-questions. So if I have the question about legal rights of nature, my sub-question would be, would it be in the form of a legal person, or would it be a different type of rights? And there would be, who would be the representative of the nature entity? Would it be a board of directors, and how are they appointed? So the governance structure. So there will always be sub-questions, and you need to introduce them in the beginning of the article. Then we go to the next slide. So if you have no idea, but I think most people have an idea, because most people have interest in certain fields, or are becoming angry about something that is happening, or are surprised about something that is happening. So, but if you have not so many ideas, or when you want to test your own ideas, your research question, you can look at the internet, you can study literature. Very important, brainstorming with your friends and colleagues and other students. Ask for reflection. So yesterday we also had a brainstorming session with Bibit and Iman about new research ideas. So that always helps to tailor-make your idea and to narrow it. Then we go to the next one. So when you write an article, you start with building you start with the abstract, and then you make an outline. In the outline, you have the title page, and about the title, there are always different ways of addressing that. You can have a very descriptive title so that people can easily find you in the internet through SSRN or Scopus. So like, I'm writing about rights of nature in Indonesia. Or you can have a funny or fancy title. Bart is very good in thinking about fancy titles.
I like fancy titles, yeah.
Yeah, like for Juridika, what was the title about Mother Earth?
When Mother Earth backed for research.
Oh,
yeah.
That's very eye-catching.
That's eye-catching, right? Yeah. It was the title of our editorial for the special edition.
Just like fancy dinner, right?
Yeah, exactly.
Yeah, and then still you can have a subtitle that is more descriptive. Yeah. So then you have the table of contents, the introduction, and then after the introduction, the presentation of the material, but that includes the history of the topic, the theory, the results, and the discussion. And then you have a conclusion, and you have the list with consulted literature, or you have footnotes or endnotes. So that depends on the journal.
Yeah, but back to the fancy title, is allowed in academic sphere if you use like poetic fancy title.
It is of course allowed because you have your own choice. But in some disciplines, it is more normal to do it.
Normal to do so. It is a common thing when we using a fancy title. Is this? It does not create just some misunderstanding. Fancy title is not academic title. It's like that. What do you think about that? To make sure the fancy title, it's still academic title.
I think that an academy can be very fancy.
Wow. Yes, that's I agree with you. That's good, bro.
Yeah, no, that's not a problem. Not a problem at all. But it depends of the text, because if you write a more essay-like paper, then a fancy title is more proper than if you write a really serious academic paper with the structure and well-used definitions.
Yeah, sometimes you can even find a good fancy title. Like we wrote a paper about chemicals.
Chemicals
in the
between us.
International supply chain of textile products. So it was a really thorough study.
True.
We had the EU Smart conference here in Surabaya in 2017. So people from different jurisdictions were helping with finding out all the law applicable to chemical pollution in the textile sector. And the title was The Chemicals Between Us.
Yeah.
And that was for textile, but also between us in the rivers and in the soil. But it was also the song title.
Yeah, it was the title of a song, The Chemicals Between Us. It was about love between two people, and it was it came from a heavy metal band.
Yes,
and it is published in a Springer book, so it's
I remember
it can
too.
be combined. Yeah.
I remember too when you giving us a chocolate free from slavery, just like
Tony's chocolate.
Yeah, free from slavery. So to make sure the worker and the other, there is no just like the new kind of slavery in the working field, like that.
Yeah.
Yes.
Okay, so then we go to the next one.
Is this the next one?
A building and outline.
Yeah.
Yeah. So the outline. So that is the introduction of your article. Usually is 1 page or 2 pages. So you describe the subject and also why you are doing that. You explain the facts and the legal significance, and which constitute the background of the paper. Well, actually, this is not the outline. This is more the middle part of the paper.
Yeah.
So it's the main body of arguments and the analysis, which is presented, followed by the conclusions. Yeah. Oh no, so it's still the introduction, but it briefly explains everything that is coming.
Yeah.
Yeah. Yeah, then the introduction should be brief and to the point. It should not only be an adapted version of the table of content. Then we go to the next one, the research methodology. I think that's more important to talk about a little bit.
Yeah.
Yeah, so there are 3 main research methodologies, I think, for legal papers. So one is doctrinal research and analysis, which is typical for legal papers. So that you look at the handbooks and at case studies, and then you publish, you ask a research question, and then you analyze and you publish the conclusion. So that is one way. It's a good way for a legal paper. A second way is a systematic literature review on a research question. And you could think, well, we always do a systematic literature review, but you don't, because a systematic literature review or a systematic review has a special format. It means that you are looking at the internet, like in Legal Scholar, for all papers published on a certain topic. Like when the topic is women on corporate boards, you look for women in corporate boards and governance. So you have some keywords that you're looking for, and then you get maybe 400 articles in English that have been published in the US, in Australia, in India, in the Netherlands, everywhere people publish in English on these topics. And then you put all those articles in an Excel sheet, and then you are analyzing what is the author, what is the journal in which it is published, what is the year when it was published, what is the specific research question, what is the method, is it empirical or is it doctrinal or whatever. So then you have an Excel sheet with all that information, and then you can discuss your results in 2 ways. You can either say, I discuss it in a quantitative way, so I would say, okay, on this topic, whether there are equal representation of women on corporate boards. There are, since 2000, a huge increase in publications on the topic. So quantitative. Or you can say half of the papers are in very good journals, social science journals. Or human rights is an important topic in all these, in 25% of the papers. So that's a quantitative analysis. You can alternatively, or both, do a qualitative analysis. So you can say, okay, there are 25 of the 400 that I found, which are empirical studies. So they did empirical research with companies about equal representation of gender in corporate boards. I'm going to analyze only the empirical papers, and then you give an explanation of what you read in those 25 papers. So that's a qualitative discussion of a systematic review. And the third method of research is empirical research and analysis, which could be quantitative. For instance, how many cases have been published in Indonesia in 2019 about bankruptcy of individual people, or bankruptcy of multinational, or bankruptcy of state-owned companies? Well, will probably not happen. So quantitative analysis. And then you can dive deeper into that. Or you can do a qualitative analysis, like all the cases that have been published by the Supreme Court from starting 2000 to 2020 on the topic of bankruptcy of companies, show that multinational companies never go bankrupt, or show that multinational companies do go bankrupt, and what are the main reasons for it, and what were the legal points of discussion in those cases. Was it Pauliana, or was it this, or was it that? The trustee in bankruptcy, how many cases did he start on this bankruptcy case? So that's a qualitative empirical analysis.
So the distinction between quantitative and qualitative is about numbers, qualitative is about matters.
Yes. Yeah. And empirical research, when do you want to do that? Well, I have here ABC. So in case you want to acquire a realistic impression of the subject to determine the relevance of the research. So you really want to dive into the societal impact. Or in case you want to get a better insight of the characteristics of your subject. So you really want to collect, like what I did with my Rights of Nature initiative. We collected 400 initiatives worldwide. So we wanted to get a better insight and understanding of the characteristics of rights of nature. So then next to that, we made a taxonomy. So we said so many were by Supreme Court, so many were by district court, so many were by law, legislation. And then third is you can also want to apply empirical research in case you wish to acquire an illustrative position. For instance, if you want to do a qualitative case study research, like with the study on social enterprises, we did a lot of case study research. So we went to the companies, the social enterprises, and we did interviews with the managers and the owners and the people that work there and the stakeholders. So why are you doing this Tony Chocolonely? We did a case study on Tony Chocolonely. So why are you starting this social enterprise? What is the aim? What is the method? What are the results? And then you're going to describe it. And then, of course, you have to put it in a theoretical framework. So you have to put it in the theoretical framework of new legal forms or the social economy policy framework of the European Commission.
Yes. Yeah, perhaps there's some kind of theory of human rights, economic rights, and the other things.
Exactly.
Yeah,
the Tony Chocolonely could also be discussed from the perspective of human rights, because it's about avoiding slavery of children. Yeah, good point. Yep. And we also did case studies with rights of nature. So we looked into the Atrato River in Bangladesh, and we looked into Atrato River in Colombia, and we looked into the river in Bangladesh and in Australia. So I worked for 2 weeks or 3 weeks on finding out why in Australia a certain river got rights and in which way it was implemented in the law. So that is also a qualitative case study. So you need to you want to find out what is happening on the ground, because it's a new area, a new development. Okay, we can go to the next. So this is Bart, what you said. Quantitative research is about numbers, and qualitative research is about what is happening in a particular group, or more to find more in-depth information about motives and opinions, desires, the why and the how question. And you can also do modest empirical research, like in case studies, by interviewing and contacting experts and stakeholder groups, or you can do it by phone or by Skype or in person. And I must say, during the COVID period, we did a lot of qualitative research with interviews, and it was much easier than before because we could do everything online.
Yes.
So it was much quicker to have an interview with people.
Yes, and have more or less cash. If we're using an online, we can cut the accommodation.
Exactly.
Yeah.
And the travel, and it takes less time for them. So they say yes to an interview. Yeah, and you get the same amount of information. You can also ask them if it's good that you tape the information, that you do audio recording, so that afterwards you can make a subscript and listen again. Yeah. So that's nice.
The benefits of a pandemic.
Yeah.
Yeah.
I think the double side of coin, we get the bad impact, but also we have some kind of good impact too. Bad practice and the good practice. Yeah. The bad boy and the good boy.
Yeah.
It depends us what you want to be, a good boy or the bad boy.
Yeah. Do you want to discuss this, or maybe you want to discuss this, or Maradona, the legal reasoning?
No, it is on yours. Because we want the participant here and me by myself want to hear this very rare moment, enlightenment from yours directly. Because if we're talking the legal reasoning, it is important for us to get some comparative opinion from our local legal scholar and the international legal scholar. But most exactly, it is from the legal expert like Tinneke.
Well, this slide is about the structure of a legal paper. So a normal classic legal paper, you can also say a doctrinal paper. And in a doctrinal paper, in a legal paper, you have to reason legally. And what does that mean? Legal reasoning means that you apply abstract legal resources like the law, like the jurisprudence, like case law and international treaties, of course, to a concrete situation. So you have to choose for a concrete situation. You have to choose for a certain jurisdiction, and then you apply the laws of that jurisdiction, the jurisprudence, etc., to that concrete situation. And then you have four types of arguments. You can do that in a descriptive way. You describe a situation. You can do it normative. Legal reasoning is always normative, of course, because the whole thing about ownership, for instance, is a normative definition. Considerations and opinions. Okay. All of them are your arguments, and what is important of legal reasoning is that it is always part of a discourse. So you choose your position in a certain field, certain legal field, and you can only choose for legal arguments. You cannot choose for moral arguments, for instance.
But there's one question that troubling me since a long time.
Mm-hmm.
Perhaps I want to hear both of your opinion. How or what we do to make sure the legal reasoning is reasonable.
Reasonable, yeah.
Sometimes legal reasoning is reasonable for us, but sometimes the other people, they say you are unreasonable. How to make sure if we're talking about the structure of legal reasoning, is reasonable not only for us but also for the other people.
Well, in legal reasoning, you have to limit your reasoning by the legal sources. So,
like a judge does.
Yes. So, reasonable is what a judge allows you to see as reasonable. So, in that's the thing with open norms. It is very important that you look at the jurisprudence.
It is same like engineering when they want to build building like that.
Yeah.
To build the reasoning, it is same like the engineering. Is that like that?
Yeah. You construct a building on foundations.
Yes.
And the legal resources is the foundation of your reasoning. If you want to build a building without foundations, then you have no construction.
But there's still room. So Bart already mentioned open norms, like in tort, in onrechtmatige daad, there are some open norms in there, huh? Like the unwritten norms of fatsoen, modesty.
Yeah.
So the 4 elements of onrechtmatige daad, of tort, is violation of the law, violation of somebody's right, violation of the unwritten norms. Yeah, due care.
Yeah.
So then you can ask yourself, what is due care? And for due care, you have to look at the societal developments. So when the societal developments indicate that we should reduce CO2 because of IPCC academic scientific findings, then, and because all governments signed the Paris Agreement and also companies were present at the Paris Agreement's discussions, so then the due care is to change your business model so that you reduce CO2 with your business model. So that's an open norm that you can fill in using information from different sources than the law.
Yeah. In the term of legal reasoning, I've heard about the legal conscience and social context theory that sometimes really broad meaning. So how to make sure that sometimes if we go to the social context theory, and the end will be in the hand of the judge because the authority of judge to make the meaning of the social context theory, for example. How as academician, for example, if we write some paper and then we want to make a legal reasoning using the social context theory, we want to give the meaning of the social context theory.
What is the social context theory?
Yeah, social context theory means that, for example, when I studied about the corporate liability, for example, how we can make sure that this act actually committed by the corporation.
Yeah.
So let's go to the social context theory when the society, in the plot of the conscience, legal say that this act actually committed in the sphere of corporation, not in the sphere of the human or natural person, for example. So I often hear about the social context theory to get the meaning about how we should give the meaning of the term related to the, for example, the corporate liability. When can we decide to how to make sure that this act actually committed by a corporation or by a natural person? So they go to the social context theory because the society right now have the opinion that this certain of act can only be committed instead of corporation.
Legal academics cannot decide; they can only propose.
Yeah.
But it's like with discussing corruption. So for many, many years, already starting in the 90s, I think, the people's opinion was that the laws on corruption and prohibition of paying bribes was not maintained by the government, that there was not enforcement of the legal norms. But then the society pushed the government to incorporate the PKK and to enhance the enforcement. So the social pressure was to more enforcement. And I think today there's much more enforcement and also less bribery, less corruption. If I'm right, maybe, I don't see what happens behind the screens, of course, but so is that what you mean? So that the societal motivation also helps the implementation of the norms that are already there. So that would be more legal social research or social legal research.
Social legal research, yeah.
And you can study that by qualitative research, for instance. So you can do interviews of experts and people who are in the enforcement division of the government. You can interview companies, how they implement anti-corruption programs to prevent that their employees are paying bribes. You can, you can do statistical analysis, even legal, like how many cases are brought to the court and how many are sentenced, or how many,
There's a big dynamics on legal faculties worldwide, and it's called ELS, so empirical legal studies. It's very important these days. ELS, empirical legal studies. Luftiadi has a question. Professor Peter said either in his book or in the class that in the legal writing there is no empirical, qualitative or quantitative method. What is your opinion of Professor Peter's thought? Professor Peter is always right, of course, and this time too. If you write legally in a classic legal way, a classic legal paper, then you don't use empirical, qualitative or quantitative methods. That's really in other methodologies. It's sui generis.
Yes. Yeah, and also it's also a matter of definition, because some people say that an analysis of cases is empirical, because that is data that you can find in society. You can find the court cases. Other people say, no, that's not empirical. That is legal research, because it's a comparison of cases. So it's also a matter of definition.
In empirical legal studies, they make the distinction between law on the books and law in action. And law on the books is, let's say, the classic way of doing legal research. And law in action is what do we see in reality? And the comparison between law in the books, so the laws, the legal sources, and law in action, what we see on the street, for instance, that is the sociological approach of law. In other words, empirical legal studies.
Yeah, but so I think Professor Peter was right, but that things are developing now into more also combinations of social legal and cultural, anthropological and legal, or statistics and legal, or empirical and legal. I think I see a lot of changes in the last 5 years.
Yeah. And since the 60s, you have also it feels like law and literature, law and economics, law and interpretation, law and whatever. So
art.
Law and art.
Yeah. Not only that, cuisine, the fusion food. So the Western food fusion with the Eastern food, just like that.
It's this fusion.
Yeah, fusion. Perhaps the new
multidiscipline.
The new multidiscipline, the fusion of the multidiscipline into the law study.
Well,
can you go back one more time? Because
sorry.
I think one other thing that was not discussed yet is you can also have legal reasoning built by opinions, so that you compare the opinions in Handbook A with opinions in Handbook B with opinions in Handbook C. So if you talk about Pauliana, is this actual Pauliana or not? Well, author A says yes, author B says yes, maybe, author C says no. And then you can apply it to a certain case, or you can analyze a new case from the Supreme Court on that.
Yeah.
That's also a way to do legal research.
Very good point. Legal reasoning. The line of reasoning can only be presented if it is sufficient, relevant, convincing, true, valid, acceptable, less authoritative. I think that's quite clear, right?
Important is internally coherent, so relevant.
Yeah.
So you cannot just throw arguments in a legal paper. You really have to make it a coherent
collection
piece of discussion.
Conclusions. Do you want to conclude, Tinneke?
Yeah. So the conclusion of your paper is the overview of your answers to the research question and the sub-research questions. And in the conclusion, you cannot introduce new information, only the information that already follows your study and the results of your study. I like it very much if you have a clear research question in the introduction and clear sub-research questions, and that you address that in the conclusion. Be careful with broad conclusions, so avoid very broad and very general conclusions. So keep it to your results that you really found. And you can say the limitations of this study are that it's only a very specific point that I researched. And maybe there's other people who want to research, the questions at my left hand and at my right hand. And so there's room for further study. And yeah, so that's good because then you can write your next study.
Yeah, invite yourself.
Yeah, and then we have some more sheets, slides on the footnotes and the citation, but we're not going to discuss that here. I think it's better to have a bit of a discussion, but you can read it, and every journal has a different way of, well, many have the Oscola, or the Cambridge style, or the Blue Book. So you must find out in the beginning what is the style of the journal where you want to publish, because it's a lot of work to change it afterwards. And sometimes you need to include the sources in between brackets, and sometimes you need the footnotes. Sometimes you need to abbreviate, sometimes you cannot abbreviate. So
take it very serious. It's very important in academic research.
Yeah, this become our faculty policy that from bachelor degree to PhD degree student, they must use Mendeley as a reference manager. So it's quite easy if they use Mendeley from the beginning. They write their paper. It can go, if they want to change to Oscola, Blue Book is going to go automatically by using Mendeley. So.
And what is the conclusion?
We just make sure the citation in the footnote is published according by the rules.
Which rules?
Our internal faculty policy, because there is if the student do not using the Mendeley as the reference manager and do not follow the footnote, the style footnote, because we have our style of footnotes for the student. So they're using it, and they're using the Mendeley as the reference manager. If they're not using it, sometimes the lecturer will not give a permission to defend the thesis.
Okay.
Yeah.
And I have a question for you. So the citation style of legal journals in the Facultas Hukum, is that the same as in Facultas Economy dan Business?
It's different. Economy, economy and business, they're not using a footnote. They're using endnote.
Endnote.
Endnote. In the economy and business, they're not using footnote.
So they don't do the in between brackets, the in-text reference.
They're using endnote.
Okay. And the social science? They do in-text reference between brackets?
I don't really, because I don't read the social science journal yet.
Shame on you. You can learn so much if you start reading social science.
Because I have already on pressure by the dean and the vice dean. The Juridika must be Scopus.
No, because if we use a Mendeley as our reference manager, so it's quite easy to change to another style. In our Faculty of Law, for example, even though we have our own style, actually it's near to the Oscola. So we already upload our reference system. And when we do, for example, reworking for our student paper, for example, if they use Oscola and then we want to go to we want to change to the endnote, for example, it can go automatically by the Mendeley reference. So that's why we use that policy to using reference manager.
Yeah, I have another question here. So if we want to publish in an international journal, can we fully use references to Indonesian language books and articles? Yes, you can. But it's good in the references to translate the title at least into English so that the reader knows to what sort of reference you are referring. And when you discuss Indonesian law, I think it's necessary to also refer to Indonesian sources. But at the same time, also try to find English language sources. But I mean, you, especially for legal articles, you really have to refer to Indonesian sources because it's Indonesian law, it's Indonesian handbooks, Indonesian articles. But translate the title or maybe in the text explain what is in the source.
Okay, but so the key is to translate the title. We must translate the title And
but also the Indonesian title.
Oh, Indonesian and okay, but not just one English the title, but Indonesian and English. Yes.
In the discussion, you discuss the things you want to discuss.
Yes.
You want to refer to the source of the discussion.
Okay.
Then you include the Indonesian title and then between brackets the English translation.
Okay, that's very important information for the participant and the audience.
What you can also do is in the discussion paragraph that you do a citation from the Indonesian source, but you do it in English, and then you say translation by the author. So non-official translation by the author, or you say it's an official translation by the court or by the legislative authorities.
Good question, Ludian.
Is there any other question from the audience?
Or other research ideas, because we can still think also about research questions. Did you think about the research question, Maradona? For yourself?
Yeah, for myself now. I have a research on progress, but it's talk about the corporate criminal defense. So about the criminal defense of corporation in Indonesian system, of course.
So it's criminal law.
Yeah, it's criminal law. And I have two actually about the corporate criminal defense and then the criminal liability of public corporation. So how about, for example, in the Netherlands, there is a gemeente or the military can go to the court.
Wow, that's a good research question. So it's not a company, it's an authority, a legal body.
Yeah, the legal body. To what extent?
A public body.
Yeah, the public body.
Okay, well, maybe Bart can answer that question for on a very high level, because he did his
master in criminal law a very long time ago.
That's awesome. But master in criminal law doesn't mean you became the mastermind of the criminal. Just a little joke.
Well, I think it is an interesting research question. It's I think specific enough. Because you narrowed it down to public authority persons.
Persons or institutes?
Institutions.
Because in the Netherlands, for example, there is the immunity for certain public bodies, right? But and it's guaranteed by the Constitution. But another, for example, there is a case about the Groningen University related to the environmental. And then calling like Marsosi related to the environmental too. We can go directly to the criminal court. But there is it's like a separation between the public institution when they exercise their authority as a public body, and then a public body when they exercise in private activities.
There's a good case, Trafigura case. It's about a ship wanted to offload dangerous chemicals in Amsterdam. And the municipality says, yes, you can do it. And then they said, no, you cannot do it. So they have to take it back in the boat again. And then I went to Sierra Leone in Africa, and they threw all the chemicals in the rivers and on the soil. So that was a major criminal offense, also violation of international law. But the Dutch prosecutor, she prosecuted the captain of the boat, the owner of the boat, and the municipality of Amsterdam for letting the ship go away, because you don't know what happens then. They could also have thrown it in the sea. So the municipality of Amsterdam should have said, we keep it here. Oh, I remember. So first they offloaded it for waste disposal. And then the municipality of Amsterdam said, well, that will cost you 200,000 euros. And then they said, oh, that's too expensive. We are taking it with us again. So the municipality should have said, you cannot take it again because you cannot bring chemical waste outside of Europe. So it was like the waste of oil production. So it's an interesting case to include in your considerations.
Yep. And then it leads to the philosophical question. One is about the moral calculation of criminal system, and then if you want to punish public corporation, it's like to move your money from the right side to the left side. Because it's go from the country, go back to the country.
Yeah.
That's the philosophical question there.
Yeah.
Very good question.
That's a very good question, yeah. I have no answer to that question.
So that's good. So there's a gap.
Yeah, there's a gap.
So let's go.
Yeah.
Let's conduct the research.
Left pocket on the right pocket, right?
Yeah. Okay. And there's a question whether we can share the presentation.
Yeah.
Yes, we can.
Yeah.
Yes.
Later we will share the presentation.
PowerPoint.
Yeah, of course.
So is there any other questions, teman-teman? Untuk teman-teman S3, saya kira ini saat yang tepat untuk share your research questions.
Well, I have one question for Bart. What is your next research idea?
My next research
Because we
idea.
had Prawitra has no time.
Yeah.
Maradona, a very good research question. We had Suleiman, a very good research question. Yeah. Maybe I'm going to ask Oleh.
Yeah.
Well, I have a new idea, and that is about. I wrote with a student of mine a article for the Dutch legal journal, Nederlands Juristenblad, Dutch legal journal. An article about. It was a comparison between the European Union law, institutional law, and the American Constitution in the time of the founding fathers. So that is legal history and European institutions from nowadays. So this one comparison is now compared to the 18th century and two different jurisdictions. And we saw that the European Union lacks a right of initiative. So the European Parliament lacks a right to initiative. And I was thinking with my student, well, isn't it interesting to have a research, to do research to the question, why don't the European Parliament has a right to initiative? Because all parliaments, all proper parliaments, have a right to initiative. So that's also a legal historical question, an institutional question, and I think that's our next project.
And I also have another project for tomorrow. And that is, I have to write about, for Ars Equi, which is also a student legal journal in the Netherlands. Very good quality.
Yeah, very.
So they asked me to write about rights of nature, but I will make it with my colleague, who's a prosecutor, the one who did the prosecution of the Prawitra. So we will ask the research question, would granting a right of nature to the Waddenzee, so the part in the Netherlands, the inner sea, the tidal sea there, would it help the prosecutors to enforce the prohibition of pollution in that area, because it's a natural area? And she is of the opinion that it would help, because it will make it easier for the police and for the prosecutors to find evidence and to have a very early warning that there is pollution. So I will write that article tomorrow and Sunday and maybe Monday.
I'm happy to read them.
Yes, same like me. Happy to read. And in the end of the season, perhaps can you give me some tips and tricks, especially, and the others generally? Just like I said, actually I have 1,000 of idea on my head, but sometimes yes, but when, just like I tell, perhaps it is my lack of my ability to using the managing time, to manage my time when I have to write, when I have to read. Just like say, it is same on me. Yes, I don't read very well on the science, the article sometimes, but there's 1,000 of idea how to implement it in the paper, so we can create the good article.
Good question, because I also have a little time only for reading and writing. That is why I write in the night often. Because during the day I have lectures and emails and meetings.
Read on the night.
So weekends and sometimes nights, because they're quiet. And for me now it's easy because I have the jet lag. Normally I can also write very good in the night, but that's not so good for your health, of course. So you better get up early and then do some sport so that your head has a lot of oxygen, like a walk or a bit of swimming. Not too long, otherwise you're tired. So like half an hour, maybe 1 hour, then take a good cup of coffee, go sit, start writing first with the abstract, then the table of content, and then start writing the introduction. Because when you start writing and do research at the same time, so you start writing on your laptop and you do research, you check internet sources on your iPad. So when you start, the story will come and the research will come. So that is that is one way. And then in the end, when you are finishing it, you can revise the introduction because maybe it turned out a bit different. Another idea is to have a group of students, like 2-3 students around you who need to write a thesis. And together you are starting a brainstorm about an interesting topic that you want to research together. And then you divide tasks. So you make an abstract and you say, okay, you are going to write the methodology. You are going to write, to do some of the research for the findings. You are going to do that. Or you can have the research question as sub-research questions. So as a team, you do a meeting one time in the week. And every week, everybody has to do a little bit because everybody has time shortage. For everyone, it's difficult to do writing. But if you do every week, Monday morning, 9 o'clock, we have 1 hour research meeting on the paper. Then in 2 months, you can have, or 3 months, you can have a paper ready. But don't make it too difficult. So if you do qualitative research with interviews, you have to plan the interviews. If you do a case study comparison, somebody has to collect the cases and then share the cases with all of them. And then you have a brainstorm about what can we learn from these cases. Or you can also do it with 1 colleague or 2 colleagues. So to divide the tasks is usually more inspiring because then you can discuss it and you get the sharper articles. So we do that a lot. And then we have 2 authors or 3 authors.
I already write that. Especially I underline, don't make too difficult.
And take your smart students.
Smart.
That's true. Always pick the smart.
We already have Diamonds. 1. I have 2 in here. That's Alvin and Mr. Sudirman.
Okay, thank you, Prof. Tinneke. Thank you.
Thank you very much.
I think we are already at the end of our session. And thank you for our audience. If you have additional question, feel free to send the question to us, and then later we will answer you with maybe direct via your email or WhatsApp.
Yeah, we're still here the next week.
Next week, Professor Tinneke still in Erlangga, so.
Or perhaps all the participants can follow the example from the Mr. Sudirman when he hear the Professor Tinneke and the Bart came to Surabaya. He already bought the ticket and came and waiting outside the building. So when I came here, what do you want to do, Mr. Sudirman? I want to see Professor Tinneke and Bart. So that's the reason I brought him in this room.
I have one more idea, if I'm about it.
Sure. Yeah,
okay. So what we also sometimes do is we organize an academic seminar, and then we ask the participants to submit an abstract, so a research idea. Then we have the academic seminar, could be with 20 people or 10 people or 100 people, like you do for your conferences. So then you have people who are good in writing abstracts. So you ask them to write a short article, like 2,000 words, 2,500 words. So then after the academic seminar, you have another meeting in which you read each other's papers in a small group, 4 people. And you make it more sharp, and then you make a special issue for Juridika, like we did also with the SMART conference. And then everybody has a clear focus, clear timelines. You ask one of your smartest students to keep the timing. And then for the people, the advantage will be that they have a guaranteed publication. And for you as a special editor, you can have the introduction to the journal, the introductory chapter. And you can work together with one of the other authors. So that also helps if you take 1 year period or half year period. So it helps when there is a certain topic, like you have a topic, this is what is necessary to be discussed. And then everybody's around that topic from different angles or different methodologies. Sorry.
Okay. That's a good idea. If you are interested in that idea, just follow the Instagram of Faculty International Office and then drop your question through direct message in TIO, Faculty International Office, and we will arrange the program for you. I think that's all. Thank you, Prof. Tinneke and Dr. Bart.
Good luck with your research and writing and publications.
Yes.
And have a safe day.
Thank you very much. And Pak Prawitra, thank you.
Thank you.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Astagfirullah.